Welcome to Norris McLaughlin's Aging Answers, a limited podcast series discussing the key topics of elder law planning and long-term care. I'm your host, Shana Siegel, practice group leader of the Elder Law Group and member at Norris McLaughlin. In this episode, I'm joined by Erdal Turnacioglu, who's going to talk to us about a new law. Hi, Erdal. How are you?
Good, Shana. Thanks for inviting me on here.
Absolutely. So tell us about the New Jersey Domestic Workers Bill of Rights.
So this was something that has been passed in several other states, including New York, California, Massachusetts, and a couple of other cities, including Philadelphia and Washington, D.C. It seems that Jersey has gotten onto the I would say bandwagon, but just in terms of protections toward those people that are working in households such as home health aides, cleaners. It really is amazing the full scope of coverage that is provided by the New Jersey Workers' Bill of Rights. It's something that was fought over for a few years and finally passed recently. And the amount of protections that it provides these domestic workers is pretty profound, all things considered.
Great. And we're talking to you because you're an employment lawyer.
That's correct.
If my clients or individuals have someone working in their home and it's a home health aide through an agency, then this law doesn't apply to them, correct?
Not necessarily, from my understanding. It looks like it can be something that is involved with a home health agency, although it's not 100% clear. But because there are certain exceptions, for example, those that are covered under Medicaid, it looks like Medicaid coverage is specifically exempt from the law.
Okay, but it does apply to private aides. So if you were to hire the person down the street or the first person that you found on care.com or someone referred from your uncle, those individuals would be covered by this law. Is that right?
That's correct. So I just wanted to point out, in the very first part of the act, it pretty much encapsulates exactly what it's sort of like the whereas clause for any sort of agreement. It just says that the legislator finds and declares that, and I'm not going to say section 1, subsection A, I'll just read it. Domestic workers provide valuable services in industries such as in-home childcare, housing, house cleaning, home care, cooking, gardening, and other household occupations. The labor domestic workers provide is an important contribution to the state's economy and prosperity, including but not limited to, by providing support services that enable other individuals to participate in the workforce. It continues, many domestic workers are women, immigrants, and persons of color who work in or about private homes isolated from other workers. And there's more in terms of the studies that are involved in developing this law, but that's pretty much what they're going for in this new law, is the protections for those people, persons, minorities, women, immigrants, people of color that traditionally were not covered even under the law against discrimination. So this really encapsulates a whole swath of people that otherwise had been ignored, not protected against. There's stories that I've seen while researching preparation for this show. It's sad what they've been had to deal with. So this law is intended to protect them against such abuse or neglect.
Sure. And in some ways, it's a great act, and it's wonderful that these individuals are now receiving this protection. But I think for employers and people who maybe don't even think of themselves as employers, but they just need help and they brought in someone to provide care to them, now all of a sudden they just need to know how to comply with the law. So if an individual wants to protect their worker and wants to comply with this law, what should they be doing? What do they have to do now under this rule?
So they're required to, first of all, create a contract with the domestic worker. And in terms of what's the scope of the services, how much they're going to get paid, those sort of things. They're required to provide meal and rest breaks for these domestic workers, at least a 30-minute meal break, for 5 consecutive hours. They have to give notice of the domestic workers' rights under the law. And there are penalties that are associated with this. Anything from, I think, the $750 to $13,000 plus.
So I think one of the things that people get confused about is the idea of an independent contractor. So am I an employer, or is the person who is coming to work in my home, are they an independent contractor? I know sometimes people think, I can get around the tax laws by saying they're an independent contractor. How does that play in here? And, is it something that that they could just say, oh, well, this doesn't apply to me because this person's an independent contractor.
Right. So, generally speaking, many of the employment laws are enacted to protect, as you would suspect, employees. So you'd have to have that employer-employee relationship. And for the most part, independent contractors are not typically covered under any of these sorts of employment or labor laws. This has effects in terms of like healthcare coverage, tax withholdings and deductions. And this is something where sometimes businesses can get in trouble with because they may think that this person is an independent contractor. And I know I'm getting beyond what we're talking about, but in terms of like if somebody's salaried, they think that it's an independent contractor and it may not be, or if it's a wage and hour issue or overtime. But with this particular law, it looks like they define, for example, an employment agency means any person or entity that procures or attempts to procure employees, independent contractors, or domestic workers for employers or companies. So it looks like this law is casting a wide net to provide protections to those who would or attempted to be considered independent contractors. It'll be interesting to see how that plays out.
Yeah. Usually domestic workers don't qualify as independent contractors, as I understand it. So I can't see that would really, you'd really be able to, claim that.
True.
Yeah.
But, just because, I've seen other instances where, for example, in the restaurant industry or the delivery services, whether it's Uber or similar things where they try to, or trucking industry where they try to label somebody as an independent contractor, even though, they control the means of transport, et cetera. So again, it's an issue where they may try to get around it, but I think this law prevents those types of schemes.
Yeah, I would think so. So we have always, way before this law, encouraged clients to work with agencies because of some of the protections. You've got those individuals that are bonded, they're trained, there's liability protection. So in general, we have recommended working with agencies. Of course, everybody doesn't want to do that. Sometimes people want to, hire directly. But can you elaborate on that in terms of like from an employment law perspective, how working with an agency might, help rather than, obviously not having to comply with this, right? But what other protections people can kind of, see if they're working with an agency instead of direct hire?
I think it's a really great idea that your firm is focusing on promoting the idea of working with an agency because, again, just like you said, they're bonded. Oftentimes they have the workers' compensation insurance that's necessary. So, God forbid something happens to that domestic worker and they get injured on the job, you'll have the workers' comp protection because it seems to me that it would be something that's, injury during the course of their employment, and other protections involved in terms of protection with wage and hour issues, making sure they're getting the right pay stubs if they have to work overtime, that there's those things in place. I think that this type of statute was created to avoid or to protect those that didn't necessarily work with an agency. It's to sort of get people to move away from this sort of hiring of those that are fly by night. I wouldn't even say fly by night, but just not really part of any sort of like agency or group that is spending the money, the investment on these domestic workers, and leaving those types of workers vulnerable to being taken advantage of. I think that once you have a domestic worker that's part of an agency, whether or not, and again, we can talk about how some employers are better than others, but for the most part, they will have the necessary, workers' compensation insurance. They'll have the necessary payroll protections in place to ensure that the domestic worker is being taken care of like any other employee.
Sure. Yeah, I think that, I get it. They're really vulnerable when they're on their own. And that's, I guess where this law comes in is to try and minimize that vulnerability. And will probably make some people more likely to go work with an agency rather than having to comply with all of these rules. I would think, maybe, but I guess we'll see what happens. One thing that concerns me about this law is how Medicaid is going to look at it. So you may be familiar that Medicaid penalizes individuals if they're applying for long-term care Medicaid for unexplained withdrawals of cash. And very often, these workers were being paid cash, and so this was an issue for Medicaid purposes. And in the past, we'd do affidavits to clarify this, but now, as I mentioned to you, I'm kind of concerned that Medicaid's going to require that every bit of this law, all of the little details must be complied with, or else you're not going to get Medicaid. So I feel like that's a big concern.
Yeah, I agree. I mean, I'm not as familiar with Medicaid as you are, but certainly there are compliance issues in terms of what is going to be required by Medicaid. If there's somebody like an elderly person being cared for by a home health aide or similar, um, because oftentimes, the government agencies such as Medicare, Medicaid, at least from the employment law context, if they're treating a particular client of mine who's on the employee side and for like bringing a disability claim, for example, and the workers' comp issue, and we end up settling the case. And this is common in the personal injury realm too. They'll do the Medicare clawbacks to get the money back that Medicare paid out for the treatment.
Sure.
Similar type of thing with Medicaid. So, at the end of the day, Medicaid's going to want to get their sort of money back or just the right protection in place, because their own interest as well to make sure that the coverage is being complete and accurate, for lack of a better term.
Yeah. One other thing I noted about the law is that there's requirements on notice for termination. And, I'm just thinking about my clients, that when a client has to go into a nursing home, or even if it's just not a good fit, they hire somebody and then it's not really working out, or when the individual who needs the care dies, like in all those situations, in the past, you would just, let that person go, and maybe you gave them a week's worth of pay or something. But now under this, there are very specific rules about what you have to do during termination. Can you address that a little bit for us?
Sure. The rules and regulations haven't really promulgated yet, but there's certainly the notice period that's in effect. You have to provide at least 2 weeks notice to terminate a domestic worker, and those that are live-in domestic workers, they're required to do a minimum of 4 weeks. So yeah, I'd never really considered what you were mentioning in terms of these issues where somebody passes away or has to go get transferred into an assisted living facility. So it'll be interesting to see how that will be dealt with. I know that from the employment law perspective, for example, with New Jersey WARN Act or the Federal WARN Act, there's requirements that they have to give you 60 days notice or get penalized. But oftentimes the employers end up just paying those 60 days as part of a compromise between the notice and, the requirement and the need to let the bulk employees. And again, the WARN Act is just a matter of, massive layoffs. So we're talking about, hundreds of people that are being laid off. Oftentimes the employer would just pay for that time. So I think that if I were going to bet on this stuff, and if I was an employer, if I was going to advise an employer without any further guidance from the rules, regulations, et cetera, I would say to sort of follow that guidance of, yeah, sure, there's issues that may come up in terms of not being able to provide for that notice period, but there are solutions, at least from the employment law realm, to be as compliant as possible.
Yeah, it's just going to cost people more money, right? And they're going to end up having to pay for longer. Okay, so I guess in closing, what would you recommend in terms of, somebody has a person in their home now, they are, it's a private employment situation, and, they learn about this. What do they have to do to comply? Who should they be reaching out to? I guess an employment lawyer like yourself would make sense, right?
Absolutely. There's certainly a lot of considerations that are in this bill. Talking to an employment lawyer, such as myself, or somebody that is within their network, would be a great way to at least comply, to set up the right contracts, to set up the right procedures in place, and to guide. Again, it's a very new law. There should be guidance that's coming out soon, but certainly if you have somebody right now that's doing domestic work, house cleaning, other sort of services like that, get in touch with an employment lawyer, make sure that you're compliant. Or like you had mentioned, hire somebody from an agency if you don't have somebody in place right now.
Sounds great. I really appreciate it. I want to thank you, Erdal, for coming on. And we actually have a blog that addresses some of this subject as well. So that's another source of information. And I know I will be encouraging all of my clients to reach out to you. This has been Norris McLaughlin's Aging Answers, a limited podcast series discussing key topics revolving around elder law and long-term care planning. I want to thank you, the listener, for being a part of our conversation, and I want to thank Erdal Turnacioglu for talking with us. Be sure to tune in next time for a brand new episode. And if you'd like to learn more about our work, please email me at aginganswers@norris-law.com.